Hey, folks, let's get back to the Karen Reed case. There's been more filings, not perfectly fine. There's always filings in a civil case. But this is regarding the O'Keeffes wanting to know more. Now, this is after Karen Reed has been deposed. And now they are seeking more information. And honestly, it's getting a bit creepy. But let's go through the latest filings regarding Karen Reed in the O'Keeffe's wrongful death suit. Welcome to the show.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for the roaring masses. Ho, 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 raise them horns, old Judge King in a crown of thorns. Santa Claus, streaming live for the roaring masses. Santa Claus, Santa Claus, Santa Claus, Santa Claus.
All right. Now, I'm not going all the way back, so I'm going to start with Karen Reed's opposition. I believe we are at. Yeah, it is. Defendant Karen Reed's opposition to plaintiff's motion to compel further answers to plaintiff John O'Keeffe's first set of interrogatories. Plaintiff John O'Keeffe, the second, motion to compel. The motion seeks information plaintiff already has, as well as irrelevant and personally sensitive medical information. The motion should be denied. Specifically, plaintiff seek the identity of Karen Reed's primary care physician for the 2 years before January 29th, 2022. A description of every prescription medication she was taking has been prescribed or had access to on January 28th to 29th, 2022, including dosages and the condition for which any such medication was prescribed to her, and her financial records that reflects the purchases and transactions she made on January 28th through 29th, 2022. Reed's medical information is irrelevant to plaintiff's claims or Reed's defenses, and is private and protected. These interrogatories amount to an improper fishing expedition targeting information for some purpose other than litigating the claims in this case. Additionally, Reed has already produced documents sufficient to provide the relevant financial information the motion seeks, including her credit card and bank statements that show her purchases and transactions on January 28th, 29th, 2022. Medical information. Interrogatory number 1 seeks the identity of Reed's primary care physician for a 24-month period from January 2020 through January 29th, 2022. Interrogatory number 2 likewise asks about Reed's physical and mental health on January 28th, 29th, 2022, including seeking a description of each medication she ingested, was prescribed to her, or which she had access to. Plaintiff also requests that she provide details as to the diagnosis for which each such medication was prescribed to her. Plaintiff states that armed with the identity of her primary care physician, they will seek her medical records. Reed objected because the information sought is irrelevant and confidential. The SGC has recognized, quote, a legislatively created policy favoring the confidentiality of medical record. Despite the fact that Massachusetts does not recognize an absolute privilege barring discovery of medical information in civil litigation, Commonwealth versus Senior, case law, footnote 1. Statutory sources concerning the confidentiality or use of medical record, including MG, hospital and clinic records, are not subject to public records request. MGL C 1011. Every patient or resident of a facility shall have the right to confidentiality of all records and communications to the extent provided by law. And MGL C 233. Hospital records produced in court must be returned to hospital upon completion of trial or hearing when no longer required. And yeah, this is getting creepy because in the not even in the trial, the criminal trial, the state got or sought 2 years prior. It was that night what happened that night, which is the only part necessary. Only part necessary. The wrongful death suit here is only about the night between January 28th and 29th. The allegations is not medical malpractice, or she took an excess amount of anything. It was she had drinks, they drove over there, and according to the wrongful death suit, she, despite the laws of physics and almost every expert, including the state's own experts and medical examiner, no, John wasn't hit by a car. It's a fishing expedition, and it's honestly a bit creepy that they go this far. Additionally, Mass General Law, blah, 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 a person shall have a right against unreasonable, substantial, or serious interference with his privacy, end quote. And there are few sources of information, if any, that are more private than a person's medical information. Now, I know that there's a bunch of people, hey, what about Proctor's medical information? Proctor himself gave that to the court in order to avoid being deposed. Do you see the difference here? He voluntarily shared it with the court. Also, according to Turtleboy, his wife spoke to everybody about her maybe soon-to-be ex-husband and his mental health problems, which extends far beyond being the racist, misogynistic, anti-Semite Austrian painter fan he seems to be. So that information already out long before Joshka Gildea did his stunt on the stand or on the chair. Including the medication she takes and the reasons for the medication. Plaintiffs have not shown any need for this information, much less a need that would overcome the policy described by the SGC in senior. In fact, Reed's health, let alone her health history from January 2020 through January 2024, is irrelevant to this case and therefore outside the scope of Rule 26. Plaintiff contends that this private information is discoverable to help him prove her level of intoxication and any additional factors that may enhance her impairment. They fail to explain how her detailed medical history will help them establish Reed's level of intoxication or cite any law to support their contentions. Instead, they rely on an apparent statement by Reed's father where he is alleged to have voiced concern to a 911 operator that his daughter, quote, had a boatload of pills because of her condition and she could take an overdose, end quote. A literal reading of Mr. Reed's alleged statement is that he was worried she could overdose because of the traumatic stress of learning her boyfriend was dead, not because she was taking a boatload of pills that impaired her driving abilities. Through two lengthy criminal trials and discovery in this case, there has been no allegation that Reed was impaired by prescription medication on the night, early morning, John O'Keefe died. Further, at the end of a second criminal trial, Reed was convicted for operating under the influence of alcohol. Although she disputed that finding in that case, her toxicology results, including her blood alcohol level during the pertinent time of frame, are a matter of public record, Thus, there is no need for plaintiffs to delve into a private medical history in order to pursue their civil claims. Such discovery is not reasonably calculated to lead to the discovery of the admissible evidence, and the resultant invasion of Reed's core privacy interest would be disproportionate to the needs of the case. Yeah, it was already a part of the criminal trial, her toxicology report. It's already been disclosed, already done. It's public record, which the O'Keeffes have access to. They already have it. This is a pure fishing expedition and nothing else. And again, it is a bit creepy. Now, we have the O'Keeffes responding to this. Let's see if they get less or more creepy. Plaintiff John O'Keeffe II's reply to defendant Ken Reed's opposition to plaintiff's motion to compel further answers to Plaintiff John O'Keeffe II's first set of interrogatories. A. Defendant's medical information is directly relevant to plaintiff's claims. Okay. Defendant Reed fundamentally mischaracterizes the nature of this litigation when she argues that her medical information is irrelevant. This is not a case where plaintiffs are seeking unrelated medical history as a fishing expedition. Rather, defendant Reed's level of impairment and the factors contributing to that impairment are at the center of plaintiff's claims. How? Unless you claim it is by accident because of impairment, but you don't claim it is an accident by impairment. You claim it is a conscious decision, which is at the center. But that goes to the blood alcohol level, not what she may or may not have been prescribed. Now, certain medication can lower or extend a level of impairment, but that information you get through testimony, which is already available. And not a single person who took the stand in both criminal trials said she was impaired. Not a single one. And even with that, 2 years prior, I do not agree here. It is a complete creepy fishing expedition. Defendant Reed's defendant attempt to shield this information is unfounded. That's bullshit. Medications can enhance alcohol impairment. Okay. It is well established that certain prescription medications can significantly enhance impairment when combined with alcohol. Defendant's argument that through true lengthy criminal trials and discovery in this case, there has been no allegation that Reed was impaired by prescription medication is irrelevant. The absence of such allegations in prior proceedings does not preclude civil discovery into these matters. Plaintiffs are entitled to conduct independent discovery to develop evidence for their civil claims. Well, first of all, you have to establish more of a foundation. Yes, Karen Reed has conditions. Okay. You also have to establish what are the most common prescribed medications, which is maybe not common knowledge, but it is easily accessible. And Karen Reed doesn't have to do anything. And from there, you can spot, does her condition is there a slight chance, big chance, an overly arching chance that her medications or the normal medications for her conditions can cause this? And you don't. Maybe they will go into it, but I don't think so. This is what makes this fishing expedition, because they have, if they've done their job right, they have already gone through, okay, this condition, what medications, that condition, what are the normal medications. If they found in there that, oh, this will enhance alcohol to a stupid level, they would have brought it forward. I don't see it. You have to show it's not a fishing expedition. Plaintiff, blah, blah, blah. Moreover, identifying defense Reed's medical medications is reasonably calculated to lead to the discovery of admissible evidence. Specifically, plaintiffs must prove defendant Reed's intoxication at relevant times on January 28th, 29th, 2022. Yeah, but that has already been testified in 2 criminal trials. How much she had to drink. It's already out there. It is difficult to understand how defendant Reed disputes irrelevancy here when her own criminal defense attorney cross-examined forensic scientist Hannah Knowles of the MSP crime lab during her retrial. During the cross-examination, Ms. Giannetti elicited the following affirmative responses. To calculate a precise conversion rate, you first need to know precisely the amount of water in somebody's blood. There are a number of factors that influence the amount of water in somebody's blood. Medications potentially affect the amount of water in somebody's blood. So, I don't... Why don't you... What? And here's the interesting part. They don't quote the answers. They do not quote the answers. And for a good reason. Because the answers would make their fishing expedition warrantless. If I remember correctly, the answers were slight to none. This testimony, elicited by defendant Reed's own counsel, confirms that medications are directly relevant to blood alcohol concentration calculations. Plaintiffs are entitled to discover what medications defendant Reed was taking to evaluate a potential impact on BAC evidence in this case. The difference here is, in the criminal case, they had to go back the morning after. And then, through some hopes of, well, if she stopped drinking at that time and started again that time, and they took the test, that means her blood alcohol level should have been this at the time of 12:25 a.m. Yeah, but it's quite clear that the passing of time, it's called. You can prove that. Now, she was convicted of that specific issue as, let's give the jury something to convict her on, so we don't have to have another mistrial. This was a tactic. It worked. It might backfire now. We don't know. I don't see how it will. But in a normal intoxicating BAC, a normal one of these cases. And by the way, they didn't specify she was convicted of drunk driving related to the alleged death of John O'Keefe, just that she drove impaired, which was that morning, which also makes this a fishing expedition. Let's continue. Defendant reads father's statements create a factual basis for inquiry. Beyond the general relevance of medical information, defendant's father's own words provide a specific factual basis for this discovery. Defendant attempts to dismiss her father's 911 statement by arguing a literal reading of Mr. Reed's alleged statement is that he was worried she could overdose because of the traumatic stress of learning her boyfriend was dead, not because she was taking a boatload of pills that impaired her driving abilities. This argument misses the point entirely. Plaintiffs do not seek discovery based on why Mr. Reed expressed concern about his daughter. The reason for his concern is immaterial through this inquiry. Then why do you bring it up? Why do you bring it up then? If it, as you have this is written, as this is written, the reason for his concern is immaterial to this inquiry, then don't bring it up. What matters is what the statement reveals, that defendant has immediate access to a substantial quantity of prescription medication, a boatload of pills, on the morning of January 29th, 2022. Access to is not, it's not, yeah, she took a boatload of pills and then drank. No. Because of her known conditions, she took medications. And also, again, to lay the foundations of this claim, they have to show these are the normal medications for her conditions. See here on these medications, these will impair. We want to know if you took additional ones, or there's no foundation here. Lay the foundation and stop being so creepy about Karen Reed's. This is Proctor level creepiness almost. This is them saying, yeah, the balloon knot, yeah, this is getting creepy, honestly. Very, very creepy. Massachusetts law do not support blanket objections. Defendant's invocation of Massachusetts privacy law does not change this analysis. While Massachusetts courts recognize a policy favoring confidentiality of medical records, this policy does not create an absolute privilege. Commonwealth versus Senior, defendant Reed's medical conditions and medications are reasonably calculated to lead to the discovery of admissible evidence because various medical conditions directly impact blood alcohol concentration test results. Certain pre-existing conditions may affect the body's fluid balance, metabolism, and liver processing, thereby skewing both BAC readings and alcohol processing rate. Plaintiffs cannot evaluate that, if any, impact these medical conditions and or medications have without access to defendant Reed's medical records. You don't need 2 years. And you have the toxicology report already. All of that, every piece of paper that are public records from the 2 criminal trials, you already have. Here, the information sought goes directly to the central issue of defendant's level of impairment on January 28th, 29th, which you already have. The requests are narrowly tailored. No, they're not! As plaintiffs are not seeking defendant's entire medical history. No, but you seek to get there. You seek her primary physician and demand 2 years of medical history. That is your actual statement. That you're contradicting yourselves here. You are contradicting yourselves here. Similarly, the request for defendant's primary care physician is routine information needed to subpoena records limited to the relevant time period. Where's the... Oh no, I lost the final part. Is there a final part? Or did I just not scroll far enough? Hold on. Dun, dun, dun. Here it is. This information is uniquely within defendant's knowledge and possession, leaving plaintiffs with no alternative source. Defendant citation to MDLC 214, 1B, protecting against unreasonable, substantial, and serious interference with privacy undercuts her argument. Discovery of directly relevant medical information in civil litigation, where plaintiffs have demonstrated a legitimate need, does not constitute unreasonable. But you haven't demonstrated. You haven't demonstrated it. All you're doing is saying, please, Judge Gildea, we guess that this might help us, but there's no foundation. There's no foundation here. Furthermore, sufficient protections exist to safeguard defendant's privacy, including protective orders and confidentiality designations. These measures can be implemented without depriving plaintiffs of the ability to pursue discovery that is reasonably calculated to lead to the discovery of admissible evidence. Defendant's OUI conviction supports discovery. Now, this is what might come back to bite. Can read that they put that in as a lesser charge, because Judge Gildea has already shown that he doesn't like Ken Reed's attorneys. He already shown that. Especially with the stunt he pulled with the so-called leak, and how he now avoids to answer simple questions, running, hiding, ducking behind an interpretation to not disclose. What information do you actually have? Who sent it to you? Because if this, folks, let's shift here. Because the only party who's been sending in stuff that turned out to be false or altered is Proctor and his attorney. Or if it was Diller, whoever it is, who has been found to produce false things to the court. And if this is another one of these stunts with the 252 tweet, and the judge is hiding from it, now he's starting to show actual bias. Actual bias. I saw earlier, before I started recording this, I saw Larry, the DUI guy, calling out Judge Gildea and saying, "Yeah, you need to be taken off this case." And I actually agree. This is Judge Gildea. In order for the judicial system to function, the judge has to at least show that he's impartial, and to the extent that even the suspicion of being partial, of not being impartial, should make the judge voluntarily step off. I do think it's time for them to ask the judge to recuse himself. Yes, a new judge would mean more costs. But at this point in time, if the Judge Gildea still evades the non-leak of Proctor's information and also grants the O'Keefes this fishing expedition on top of that in the wrongful death. I mean, I know it's two parallel cases. I know that. But seriously, it's time for him to step down if he, on top of that bullcrap, also allows the O'Keefes this fishing expedition. Was it anything else? Dun, dun, dun. Nah, it's just more garbage. Folks, the Karen Read case keeps going on, and nobody goes. The only people who seem to care about John O'Keefe is us and Karen Read. The only people who cares about John O'Keefe. It doesn't even seem like his family cares about him anymore. Oh, I saw that Adam Deitch was being interviewed the other day. Let's play a few minutes of this. So you as well, because when it comes to who will get to the bottom of this, I think this is the guy. Let's play the first few minutes here, and then get over to it. Who is it? It is the CBS Boston who has this interview. All right, let's take a listen.
Thank you for joining us.
Thanks,
Appreciate
Christina.
it.
It's great to be here.
I'll give you the same starter question I gave everybody, which is also probably the easiest. Introduce yourself and tell us why you're running.
Of course. I'm Adam Deitch, and until November, I was a federal
Deitch.
prosecutor at the U.S. Attorney's Office in Boston. I was doing mostly public corruption cases around Massachusetts, but ultimately had a series of cases taking place in Norfolk County. And it got to a point where I was looking at case after case, and I literally said out loud, what on earth is going on in Norfolk County? So I launched this campaign, and I'm running now full-time because I believe what this DA's office needs is wholesale, cultural, systemic change, the kind of change that can only come from a change in leadership, ideally an outside perspective, somebody who has experience prosecuting police misconduct cases and public corruption cases.
Yeah. Regarding, I mean, Trooper Proctor, Sergeant Good, and the other who should never have set foot, who should never have been police officers. Their conduct, yeah. And can you actually trust somebody from inside who has anybody who works with under Michael Morrissey right now can't be trusted with this position, because they saw this happen in real time and did nothing. You can't trust them, any of them, to actually work towards a change. And also some of the other, if I remember correctly, from a month ago, about where they had a panel, and 2 or 3 of the people who are running for the DA's office still say they would have prosecuted Karen Read, despite everything that has happened and come forward. Seriously, none of them should render a vote for them, because they are there to keep Michael Morrissey out of trouble and nothing else. Let's keep listening.
Why would you leave a federal job to try and be a county district attorney?
Yeah, so I think, for the longest time, being a federal prosecutor was my dream job. And when I got a job in the Boston U.S. Attorney's Office, one of the most elite prosecutors' offices in the entire country, I was beyond excited. Coming back to New England, where I grew up, and I loved every minute of that job. But literally, I started working on cases in Norfolk County and saw things happening that made me realize this district attorney's office is broken, and I am uniquely situated to solve those problems.
Yeah, now, Deitch is under a certain form of confidentiality. He cannot disclose everything he knows, but he knows enough to want to leave that elite DA's office to get Norfolk County DA's office back on the right track. I mean, the insinuations here are enormous. He knows. He probably already knows about the inner workings of the Sanna Bergström case, the inner workings of the Karen Reed case, the Miles King case, and many other cases where Trooper Proctor, Sergeant Good, Tully, Buchanan, and the other misfits have been ruining, potentially sending actual innocent people to prison through their complete and utter corrupted bias. Why wouldn't you want Adam Deitch? Well, because you want to protect the corruption.
Okay, I've asked everybody this as well, and since you're talking about how you feel like an outsider needs to come in, what would your plan be if you were elected to this position as far as staffing goes? There are people who've worked there for decades. Would you be cleaning house? Would you be making people reapply to their jobs? What would your plan be?
It's a great question. And I think, first of all, the next DA is going to have to demonstrate a level of firm, thoughtful, decisive leadership. I think, number one, there are a lot of things this DA's office does well. And there are people who are career public servants who go into work every day. They work hard. They do the right thing. I want to embrace and strengthen the things the DA's office does right. But I think what's happened over the past few years is that it's not just me, and I'm sure it's not just you. A lot of people have seen how broken aspects of what this DA's office does has become. And so we're going to need to make real changes. And nothing will happen overnight, by the way, but we're going to have to be firm and decisive about what is broken and how to fix it, and bringing in new blood and new people to handle some of those tasks. It's not just the DA's office and the prosecutors and the legal staff. It's also the state police detective unit that is housed at the DA's office. Right. They report up to the DA, and they lead investigations of unattended deaths throughout Norfolk County, including, of course, in the death of John O'Keefe and the death of Sandra Birchmore as two very high-profile examples.
But your plan is not to come in and fire everyone.
No, and I know there's a candidate in the race who has said that everyone in the office is going to need to reapply for their jobs. Mm-hmm. That is not my message at all.
Okay.
And I think I want to meet people where they are. I want to be thoughtful about the leadership of the office.
I understand him. I mean, there are probably people in the DA's office and in the the cops unit that actually does a good job, who are waiting for the right leadership. So, because as of now, if anybody speaks up in the DA's office and the cop unit, their careers are ruined by the corrupt leadership of Morrissey. And as soon as Morrissey is gone, and hopefully Mr. Deitch is in place, they can feel the confidence of walking into his office and say, "Thank you. Now I can finally speak up.
And I want to make sure that I get to know people who are there before making, some of the more significant personnel changes that ultimately will need to be made. I'll also say this: it won't just be me. I intend to bring in a team to help me lead the office, to balance out my federal criminal experience with state criminal experience. And the key aspect there is I will bring people who've been supervisors in other DA's offices, for example, who share my values and share my positive vision for the future of the Norfolk County DA's office.
Yeah, also, here he has unique insight, because he hasn't just worked and checked what's going on in the Norfolk DA's office. As a federal prosecutor, he has seen where there are good people and where there are not good people. He can literally pick the best of the best. Now, I can't predict the future. Nobody can. But it seems like he's the best fit right now.
So we're going to get into the specific cases that have kind of plagued this county lately. But first, I want to ask you about DA Michael Morrissey in particular. He's been the DA for 16 years. He's not running for re-election. Obviously, all of you are running to replace him. What's your position on him right now, and in particular, how he's handled the public pressure the last few years?
Yeah, I mean, I'll go backwards. Just a few weeks ago, when a trooper who's in that state police detective unit, Michael Proctor, when his text messages became public, I immediately, that day, I think on your air, called for Michael Morrissey to resign his position immediately. It shows a utter lack of supervision of that state police detective unit, and it's just another horrifying illustration of some of the cultural problems that have been allowed to fester in the DA's office. This is one trooper whose text messages the public has now seen, and they are the most horrifying, racist, bigoted, misogynistic, anti-Semitic, homophobic text messages that I think anybody has ever seen. And it demonstrates a failure of leadership. Anyone who's in that line of supervision should be held responsible for what's been going on. I was one of the candidates in this race who started my campaign before Michael Morrissey decided not to run.
Right.
And in fact, I launched in November, and it was a few months before DA Morrissey decided to get out. Now, I'm not saying there's a causal relationship between my campaign and Michael Morrissey deciding not to run, but I'm not saying that.
Okay.
I'm kidding a little bit. But I think the reality is it is time for change in Norfolk County. And maybe DA Morrissey realized that as well.
Okay.
Yeah. Now, folks, the rest of the interview is great. So, but I don't want to take viewers from CBS or UBS or whatever the channel is. I will link in the description the interview where you can find it. But yeah, I mean, I know that the O'Keeffes are seeking damages for more or less everything. I think it is absolutely... They have listened to the McCabe's and the Alberts, Higgins, and it has been... They've listened to the wrong people. Karen Reed did not kill John O'Keefe. Physics says so, and the other evidence says so as well. The only thing the state brought forward was Blue Man Group impersonators and bullshit through and through, because they knew early on, they knew early on they didn't have the evidence. But they went forward anyways to protect Proctor, to protect Good, to protect the McAlberts, to protect Higgins. It might not have started that way, but they realized early on they were in a clusterfuck, and then they decided to take the wrong route. And why? Well, my gut reaction is because they agree with Proctor. And that is also why Morrissey has to go, and a bunch of the people in the DA's office, including this cop unit, they have to go. And new, fresh people who actually has integrity has to move in. Folks, that's my update on the Karen Read case. And yeah, as always, I will keep looking into this case. I might not do a video or a stream every time a new document shows up, because honestly, most of them are just procedural and boring. But when something interesting like this, the fishing expedition, and Mr. Deitch is on an interview, of course, I will do an update for you. All right, folks, that's what I had for you. Thanks for tuning in. You all have a good one, and I will see you in the next stream or video. Bye-bye.
Santa Claus, riding in with the winter laws. Santa Claus.